A Trump prosecutor has been busted. Her bias is now obvious after Trump defense attorneys unveil a letter that she sent to Bill Barr well before January 6th even started, well before the so-called insurrection occurred. This is a letter from Molly Gaston, the highlighter girl, the one who said that Trump and his defense team in the January 6th case don't really even need to read the discovery because she organized it so well with a bunch of binders and tabs and highlighters. And she said, this is our theory of the case, so you don't need to read anything. And we're like, what? The government can do that? Well, now in Judge Chutkan's courtroom, apparently she can. But this comes in Trump's motion for selective and vindictive prosecution for a dismissal on those basis, because he's saying that they're targeting him, right? This has been a long operation since well before the so-called insurrection even occurred. And this is his reply. So he initially filed a motion to dismiss, then the government responded, Jack Smith, and now Trump is replying, and he's including some very nice exhibits, including sharing with us his demand for discovery. He's also explaining what they're asking the government to give to him. And it is a long list, a long request. They want a lot of stuff, as they should. It's a big case. So let's go through it and see what is inside Trump's motion to dismiss for selective and vindictive prosecution, starting with Trump's reply. You can see it's a 12-pager, not too long. We'll hit the highlights. United States of America versus Trump. And this was filed in the D.C. court, which is Judge Chutkan's courtroom, on the January 6th case. Trump says, all right, look, this is the final word on this. So here's my reply. We say, dubbing team members, quote, career prosecutors, this is Trump writing, in further support of his motion to dismiss, saying that Jack Smith just dubbing people career prosecutors does not insulate the activities of the special counsel's office from judicial or public scrutiny, okay? Just because you work at the DOJ doesn't mean like you're above the law. Now, they say that Trump is not above the law, but they act above the law all the time, obstructing Hunter's investigation, maliciously prosecuting their political opponents, the list goes on. Trump's defense says, the reliable media reports submitted by President Trump, which we submitted in our initial motion, which are based on information from other, quote, career prosecutors and government officials, demonstrate the unconstitutional nature of the investigation by Jack Smith's office and the line of deranged thug prosecutors there. If the, quote, career prosecutors in this case, if they wanted to dispute the content of those reports, and so we have to fill in the gap here a little bit. Jack Smith already replied, and we saw Trump's initial filing, and so they're saying that in Jack's reply, they were making some claims, and Trump is responding to those now. If they want to dispute our original allegations that we filed, which we did, we read through here, there was a straightforward way to do that. All they could do is submit declarations by the first-hand witnesses denying the operative facts under oath. So they're saying, look, if we submit a New York Times story and you think that our story is fraudulent or something, you can submit opposite facts. If, for example, the New York Times falsely reported that Biden told others that Trump, quote, should be prosecuted, if the New York Times was wrong, then why not give the court and the public peace of mind through the submission of competent evidence rather than a blustering brief that is full of venom but deflects on the core facts? We're in the court of law, Jack Smith, and you prosecutors there. Why do you have to go psycho mode when we just bring up a simple fact? All we did was just show you this New York Times article. It's here. It's your magazine, okay? It's your article. It's your journos over there copying and pasting everything, frolicking around with Merrick Garland. Like, where do you think they heard this from? So we just showed you one of your own propaganda rag's own stories, and then you went into Psychoville and you put out this blustering brief. How about you just respond to it and just say, no, that never happened. You know, here's some facts to show that. The answer is simple. The reason why they didn't do that is because the media reports are accurate. Now, they're full of a bunch of bluster and crying, caterwauling, but here it's true. Thus, despite all of Jack Smith and his prosecutors, all of their self-aggrandizing comments about the supposedly unprecedented nature of his manufactured allegations against Trump, the truly unprecedented aspect of this case is that a sitting president successfully urged the DOJ to try to take down his chief political rival and now the leading candidate to be the next president. Yeah, so don't tell us about Trump unprecedented this. You broke precedent. 234 years of historical precedent. We've never prosecuted political opponents in this country until Joe got in. Now, President Biden was so successful, in fact, that the special counsel brought two deeply flawed cases against President Trump and has since engaged in a reckless effort to proceed to trial in both cases as soon as possible, even while President Biden anxiously waits to learn whether he will be charged by crimes by a different special counsel. Spoiler alert, no, he won't, because there are double standards in this country. Now, the Biden administration may not, through this prosecution, retaliate against President Trump for speaking out or for exercising his constitutional right to run for office, nor may the prosecutors in this case, like Molly and Jack and Jay, do President Biden's impermissible bidding. Because the special counsel's office has not submitted any evidence to refute or or even dispute President Trump's proof about the biased and unconstitutional purpose of this case, the court should dismiss this indictment. In the alternative, you must dig into this further. So they're basically saying, Judge, we showed you something, okay? We have a New York Times report that says Joe Biden did this. All they did is come out and just pound the table. So if they have some alternative facts, we'd love to hear it, but they don't. And so since they have provided no showing at all, this indictment must be dismissed. So they say there is much more than an indication, right? The law says there's an indication. Or Jack Smith says that there is no indication. They say, yeah, right. The special counsel's office, Jack Smith and Molly, they declare without basis that, quote, the factual and legal record contain absolutely no indication of selective or vindictive prosecution. Now they say that's not accurate here. First, evidence of the insidious and unconstitutional bias at the heart of the prosecution in this case emerged within days of the 2020 election. We're going to dive into this letter, but on November 12th, Deputy Special Counsel, this person called J.P. Cooney, and Senior Assistant called Molly Gaston. Wow, Senior Assistant Special Counsel Molly Gaston. You know her here as Highlighter Girl from other segments where she was saying that Trump and his defense didn't need to read anything. Yes, there's 13 million pages of documents, which is more than in cases like Walmart versus Visa. Walmart versus Visa took like 7 years to resolve. They're going to do Trump's in like 9 months. Walmart versus Visa had like, 7 million documents, give or take. This one has like 13. So 7 years, 7 million docs versus about 9 months and 13 million docs. So how can you possibly prepare your case? You can't. That's the point. So back in 2020, Molly was already on this. Okay. She signed a letter to Attorney General Bill Barr, and they declared back then, prior to any investigation even happening, prior to even the counting of the electoral votes, they declared that allegations about election fraud were, quote, false. And they signed that letter as U.S. attorneys at the District of Columbia, and they had no basis in fact or any investigation to support their sweeping claim. And that's available at Exhibit 1, and that's on the internet in the FOIA library. You can just go get it right there at justice.gov. And let's take a look at it since we have it pulled up. This is what Molly said, right? This is supposed to be an unbiased prosecutor who reviewed the facts of the case and made the determination that there's probable cause here to prosecute Trump. She writes this: November 12, 2020, days after the election, no investigations had been happening or completed, and we haven't even counted the electoral votes. So she and her people, okay, let's make sure that they signed it. There it is, Molly Gaston. Now she's a main prosecutor in this case, in the current Trump case. So she's signing this well before anything even happened. Okay, we're still like catching our breath because Trump was well ahead on election night until all the spikes and all the water main broke at Fulton County. So you see, this is the letter. Let's see what they said. They said, Dear Mr. Attorney General Bill Barr. Okay, so Bill Barr, of course, we know him as an institutionalist, the former AG. So he gets this letter from his own staff, and it probably freaks him out. He's like, oh man, the criminal division, and Liz is sending, and JP, and Molly, and they're copying everybody, right? So this is like the employees putting pressure on the boss to don't go anywhere. They say, we currently serve at the Public Corruption Division, and we share responsibility, but the views expressed below are our own. So they're like they're not writing as officials of these institutions. We share responsibility for enforcing this, but we're not writing on behalf of it. All right. Well, we write to voice our support for the nonpartisan career prosecutors in the Public Integrity Unit, especially Richard, whose faithful administration has protected the institution from political partisan. Oh, gag me on this one. We, along with scores of other career prosecutors, were demoralized by his need to resign because he has stood steadfast against political influence. But we believe, Bill, that your November 9th memorandum about post-voting election irregularities, in which you altered, Bill, the long-standing non-interference policy, eradicates the DOJ's guardrails against improper political influence. Which is like, are you kidding me? These people, the improper political influence is that they don't have the ability to continue their political influence. They're like, hey, we love our political influence. It's improper for you to take it away from us. The process leading to the memo, which prompted the resignation, along with its timing, was the elimination of the policy requiring the U.S. attorneys to consult PIN before initiating ballot fraud investigations, all right? So in other words, you had to go through this guy in order to conduct a ballot fraud investigation. So he resigns, and then they throw a hissy fit. Well, he's resigning because you're taking away a guardrail. No, he was the choke point. He was the one who'd said, oh, well, yeah, no, I mean, this ballot fraud investigation looks like it might uncover massive ballot fraud that would re-elect Trump. So obviously I'm going to reject that. So they took out the choke point, and now they're, moaning. So first, the process by which you change the non-interference policy diminishes the public's confidence in the department's political neutrality. Such a process violates the norms. And second, the timing of your decision is changing. It's putting us in a political thicket. You issued a memo within days of a polarizing election, which the DOJ DOJ, failed to secure or secured for themselves during a time in which the false elections of widespread voter fraud are running rampant. That has not been concluded yet. This is November. We didn't even have litigation that was completed yet. So these prosecutors have already come to a conclusion without any investigation. Shows you how biased they are from the outset. Your abrupt decision to revise the 40-year policy is unseemly, and it seems like we're engaging in political partisanship. And finally, your memo apparently eliminates the written policy and blah, blah, blah. And so your process that you reached, coupled with this, undermines the department's commitment to non-interference, and this guy resigned because he felt threatened by you, and we're very upset with you. And Trump is a liar, right? So fix this. Sincerely, Molly Gaston. So she's already come to her conclusions. She's already, without any investigation at this point in time, because this is in November. November 12th, the election was like a week before. They're already firing off letters. Hey, you can't change stuff. How dare you start to investigate things and change the rules so that you can go investigate things? You're supposed to go through this guy. You can't launch ballot fraud investigations during this period, and you doing it is violating the standard norms. And so we should be allowed to conduct our fraud without anybody looking into it. Sincerely, Molly, the same person who says Trump is an insurrectionist. So she never looked into this before, coming to her conclusions, clearly partisan. They write, Cooney and Gaston, that's Molly, the one we just heard from, those two, they are now prosecuting the indictment in this case, in which they have alleged that senior leaders of the DOJ, that they told President Trump on multiple occasions that various allegations of fraud were unsupported. So in other words, they're the people telling Trump, right? The DOJ's telling Trump, and Trump's not listening to the DOJ, and so they're charging him, kind of a thing. He's the president. He has the discretion to dismiss senior leaders of the DOJ. I'm not going to listen to you. I'm the president. You're not. Thanks. So for Cooney and Gaston, at least, this outcome was predetermined before mid-November 2020. And what followed then cannot accurately be characterized as a thorough and impartial investigation. It's not impartial. She had this conclusion underway before the investigation even started. Rather, as the unrebuted facts make clear, the prosecutors decided to charge President Trump regardless of the facts. In February 2021, for example, Cooney proposed a wide-ranging effort to target President Trump that concerned the FBI. Cooney's proposal was ultimately rejected because, among other things, it treaded on First Amendment protected activities. Oh, they didn't do that one. Yeah, they wanted to get him immediately. February 21, let's go take him out. We also see here, the U.S. Attorney's Office for D.C. eventually spearheaded the investigation until Jack Smith got appointed. Now, before Jack Smith was appointed, guess who was there? Cooney, Gaston, and others, including Thomas Windham. They led the investigation, and after Jack Smith got appointed, they all went over there. So they all joined in. So in addition to Attorney General Barr, Cooney and Gaston, they also sent a letter to Richard Donahue, another potential prosecution witness. So they're influencing the case. Back in 2020, the letter raises serious witness advocate problems with respect to their anticipated testimony, which we're going to address in motions in limine if necessary, right? So now, when they call this witness, Richard Donahue, they'll say, well, weren't you communicating with the prosecutor before this case even started? The answer is yes, they were. They were sending him, hey, there's fraud, before they even did their investigation. And what's so disgusting about this letter is, like, they're obviously partisan, right? They're obviously saying that there is no fraud. False allegations of widespread fraud are running rampant. Did you even investigate it? Like, Bill Barr is initiating an investigation, and you're already coming to the conclusion. In fact, you're mad that he's initiating the investigation outside of your guardrails so that you could dismiss it by not going through the PIN. So they continue. They say, here, during the same month, then acting U.S. Attorney for the District of Columbia, Michael Sherwin, he began, quote, agitating for a hammer while physically carrying the seditious conspiracy statute around his office. Okay. He began agitating for a hammer, and he was literally probably carrying like a picture frame of the seditious conspiracy statute. I told you, man, these prosecutors are weirdos. So Michael Sherwin, they're weird. So they like salivate over. It's like a bloodlust. It's like, kind of a sick obsession, especially when you combine, like, just think about a regular prosecutor who's already a little bit weird, and then add in like TDS on top of that, and then put him in Washington, D.C., and put him around a bunch of other kind of bloodthirsty lunatics. Like, they're weird. They're walking around with statutes and stuff. Probably puts it under his pillow. Weird. It's like, do you have a family? Like, do they know where you are? I don't know. So in March 2021, during a 60 Minutes interview, in violation of DOJ policy, this guy, so excited about prosecuting Trump, it's his life's work now, even though he's like a sworn prosecutor. What are you doing? Sherwin declared publicly that President Trump was being targeted by the DOJ and suggested that statements from, quote, soccer moms had moved the needle. In November 2021, Senior Assistant Special Counsel Thomas Windham doing the same thing. November 2021, he put forward an investigative proposal. He targeted President President Trump's close associates, which was met with, quote, flat rejection, with one FBI official declaring, "You don't have enough to issue subpoenas." Okay, so just to zoom out on this very briefly, all of this is happening before Jack Smith is even created, right? Jack Smith has not even been appointed yet. So these people are already investigating Trump. And by the way, Jack Smith is supposed to do a fair and impartial investigation, right? He's supposed to be a special counsel who's a neutral party, who comes in and does an investigation outside of the DOJ, because we have questions that the DOJ is being weaponized by Joe Biden. So these people, prior to Jack Smith coming in, they were already trying to prosecute Trump, right? They had no new investigation outside of the confines of the DOJ under the jurisdiction of the special counsel. They were already doing it. And then as soon as Jack Smith came in, they just slotted him in. They just moved offices. They just packed up and went over to Jack Smith's office. The same people who already had come to their predetermined conclusion. Sherwin said it in March. Thomas Wyndham said it in 2021, November. In the weeks that followed, rather than recognizing the lack of an evidentiary basis for this, and by the way, those were rejected. FBI said, no, you don't have enough. So instead of going through the grand jury proceedings, Wyndham discreetly, and this is from another footnote, says he asked a different agency if it, quote, might help with the bias project that the FBI had declined to pursue. So they're just trying to make it happen, right? They're on a mission. Now, second, they say, well, let's back up. This came from CBS News, and they say, notwithstanding the above quoted language specifically referencing President Trump in the 60-minute interview, Sherwin, they say the special counsel's office contends that the interview pertained not to the defendant, not to Trump, or any prosecution of Trump. Now, these are false claims. They say they serve as further evidence that the prosecution is willing to say whatever it feels best that suits its objectives in a particular moment without regard for the truth. They're liars. If the office's assertions regarding the scope of the interview are correct, then the prosecution has no basis to contend, as it recently did, that President Trump is responsible for the events of the Capitol. Yeah, so either he's talking about Trump or not. Like, if he's not talking about Trump, and he's talking about the other people, and then he's blaming the other people for the events of the Capitol, because it was in the context of the events of the Capitol. So who's responsible for it? So Trump's defense continues. They say, second, as President Trump criticized the Biden administration, and as he suggested that he would run in 2024, then President Biden urged his, quote, inner circle. He said that President Trump was a threat to democracy and that he should be prosecuted. Now, President Biden also said that he wanted Attorney General Merrick Garland to act less like a ponderous judge and more like a prosecutor who is willing to take decisive action. That's a footnote from the New York Times article. Now, the Biden administration then intentionally leaked these comments to the media in early 2022 so that President Biden could improperly provide instructions to and exert pressure on prosecutors and investigators without engaging in direct communications. And as is clear from the fact that the article sourced the operative remark to, quote, two people familiar with his comments in the New York Times. And if Jack Smith debates that, well, let's see it. Bring it out. So they say, unmoved by such intimidation tactics, Trump will not be perturbed. President Trump maintained his criticism of the Biden administration, and we got a groundswell of support leading to Trump's 2024 candidacy. Now, on November 9th, 2022, and remember, all of this stuff from Wyndham and Sherwin, it was all happening before this. Just days before President Trump announced his candidacy, President Biden issued a final, it's hard for me to say that, says that he issued a final ultimatum. He says, quote, we just have to demonstrate that he will not take power if he does run. President Biden's threat was clear. Days before Trump chose to run, he said, if Trump chose to run, President Biden would bring the force of the government down upon him. But once again, undeterred, President Trump did announce his candidacy. And then President Biden made good on his threat. Within days of President Trump's announcement, the Attorney General appointed the special counsel Jack Smith, who filed a false indictment against President Trump in Florida in June of 2023. And after President Trump publicly criticized Biden and Jack Smith for engaging in prosecutorial misconduct and improperly weaponizing law enforcement to harm his campaign, boom, this indictment followed. And they say, Your Honor, that's why we're here. They say the motion here is supported by facts and evidence, saying the special counsel's office, Jack Smith, has relied on media reports from the Washington Post and other sources throughout this case when the prosecution approved of the report's substance, saying they cite the media all the time. And he gives a bunch of docket examples. He says, if you want to see where the government references the media and they're like, hey, the Washington Post said so, they've done that at docket entry 97, docket entry 109, docket entry 140. Just go look at them. They reference them all the time, says the defense. But because here, President Trump relies on two articles that the office from Jack Smith appears not to like this time, at least in public, the prosecution seeks to relegate them to the level of, quote, spurious allegations contrived from newspaper articles citing anonymous sources. It says the court should see through that ploy. Reports at issue are not, as the prosecution claims, based on rumor and innuendo. In fact, the Washington Post says no. It's based on internal documents, court filings, congressional records, handwritten contemporaneous notes, and interviews with more than 24 current and former prosecutors, investigators, and others with knowledge of the probe. They all know. The New York Times article is also attributed to interviews with more than a dozen people, including the Biden administration and people with knowledge of the president's thinking, all of whom have asked for anonymity to discuss the private conversations. So the two favored institutional propaganda rags that the left normally relies on, including the Biden administration, the New York Times and the WAPO, they both have deep investigations that both come to the same conclusion. They say, for example, President Biden's instruction to President Trump that, quote, should be prosecuted is sourced by two people familiar with his comments. Now, the government says, well, those media reports are insufficient. Say it's too far removed. It's not related enough. But here, the evidence directly implicates Biden, as well as the line prosecutors. It's not removed. In the absence of the government's firsthand declarations to the contrary, like, Jack, if you've got something else to show, if you've got other evidence, this is pretty good. If you think we should disregard it, then submit it. If you think you've got stuff to diminish our evidence, let's see it. Now, they say, Judge Chutkin, the presumption of regularity that special counsel seeks to hide behind, not entitled to any weight. He says, now, normally, we give the prosecutor the benefit of the doubt. There's kind of a presumption that they're not corrupt, partisan, prosecutorial, hack deranged thugs. So we'll give them the benefit of the doubt normally. But in this case, President Biden has driven a prosecution that is wholly inconsistent with that clause and is instead motivated by a constitutionally prohibited desire to pursue election interference by punishing Trump for his protected speech, for his decision to run for office, and for his status as the leading candidate in this election. Now, the evidence also demonstrates that the prosecutors at times acted based upon a similar political bias, which led them to make unsupported assertions and press for investigative steps that violated the very Constitution. There exists the type of clear evidence to the contrary that warrants setting aside the presumption of regularity, and so we're not going to trust Jack Smith, saying that once the motion establishes selective prosecution, you need to take actions. Now, once the presumption is appropriately stripped away, this extraordinary fact pattern, right, saying Jack Smith is not given the benefit of the doubt here, this fact pattern, coupled with the extraordinary history of prosecutorial inaction in connection with the controversial presidential transitions of other elections, is sufficient for President Trump to make out a prima facie case of selective prosecution, meaning it's evident on its face. We've already proven it. Here, we don't even need to show you anything else. They say the case is unconstitutionally selective and it's motivated by a discriminatory purpose because Biden singled out Trump based on unconstitutional considerations, and Jack Smith's office has acted at Biden's inappropriate direction. Jack Smith claims that none of the other 7 other elections identified by Trump as comparators involved deceitful or corrupt efforts, right? And so what Trump did in his original motion, which we did read here, was say that there's been a bunch of other close elections and a bunch of people have challenged elections before, but they say, oh no, but you were corrupt. However, a law review article cited by Jack Smith, they describe an 1800 election that had involved a protracted unintentional delay by Federalists in the House of Representatives, posed a fear of possible armed revolt. And then they try to distinguish that case, saying that Jefferson's conviction was sincere, but Trump's was not, right? So Trump is doing this corruptly, but these other guys were not. They say that's neat. That's pretty interesting that they come up with self-serving discretionary judgments out of their own, evidence. It pervades their efforts to distinguish all of the other 6 elections. This election was no different, but these are not the sort of distinctions that can defeat a selective prosecution motion. So instead, Jack Smith tries to deflect, typical. So he declares that individuals prosecuted in the physical president's cases related to J6 are obvious comparators, but none of those cases involved the package of charges levied against Trump. All he was doing was speaking out against election fraud, and he wasn't even physically there. Even the politically motivated prosecutors responsible for this case, they did not dare to bring the seditious conspiracy charge that Sherwin, weirdo, was walking around with his office. Moreover, the prosecution's impermissible motives are laid bare by the citation to the Rhodes case. In March 2022, before Biden and his declaration that President Trump must be prosecuted, DOJ prosecutors argued that Rhodes acted independently of President Trump. That's Stuart Rhodes from the Oath Keepers. They said there that he had an intent to fight to stop that result with or without President Trump calling them into action. And during the Oath Keepers, they said, yeah, Mr. Rhodes was clear that if Trump didn't take action, they would. But now that Trump is the leading candidate, they now argue that Trump and Rhodes are the same. So why do they keep making changes to their stories to assert their case? case. They say President Trump has also shown that these people are vindictive and a clear showing of vindictiveness under the law. A case cited by Jack Smith establishes that Trump can meet his burden through evidence that the prosecutor was prevailed upon to bring the charges with an animus that could be considered to making the government a stalking horse. Has that standard been met? Trump says, yeah, absolutely. That is precisely what President Trump has demonstrated. Biden's public statements and news reports that are based on leaks from former members of his team. The special counsel is President Biden's stalking horse. It's a highly publicized case in Florida and in D.C. And line prosecutors, like Molly, took politically biased steps during the investigation that suggest that they have personal stakes in the outcome. And we've met the presumption of vindictiveness. The inference of vindictiveness is further supported by the fact that before Trump even declared his candidacy, Biden urged for his prosecution. And the DOJ at that time declined a proposal by the National Archives to investigate the use of electors in the 2020 election and alleged documents that Trump used to pressure Pence not to certify the election for Biden, enabling the National Archives to open the inquiry, essentially. Now, the special counsel's office contends that an inference of vindictiveness is less appropriate in pretrial settings like this one, because this is a time when the prosecution and the prosecutor's assessment of the extent of the prosecution may have not crystallized. But to the extent that their crystallization is necessary or relevant, it only supports dismissal. They recently suggested Jack Smith is going to seek to offer evidence of J6 violence at the Capitol at trial in this case, which is a position the prosecution announced only after President Trump made public statements criticizing the prosecution and filed pretrial motions defending himself. So, in other words, Jack Smith doesn't even really have a good idea of what he's doing, right? Hey, we're still theorizing our case. So, well, if you're just now going to introduce violence, maybe the probable cause, the original basis for bringing this case in the first place, wasn't justified because you're making it up as you're going along. They say, all right, Your Honor, at a minimum, we need fact-finding to resolve these motions. You need to schedule a hearing so we can present evidence. I want to show you more of these exhibits, they're arguing, saying the prosecution suggests that Trump must provide exceptionally clear proof to obtain a hearing on this motion. But that's not the law. They say a defendant who seeks discovery of selective prosecution must show some evidence of discriminatory effect and discriminatory intent. And on the motion for selective prosecution, Trump says some courts have lowered the standard for discovery in selective enforcement cases by jettisoning the similarly situated requirement for the discriminatory prong and making the standard a little bit looser. And we meet that standard. And they say, Your Honor, Chutkin, by the way, Jack Smith and his office, they profess confusion about what the fact-finding would entail. What is this going to involve? And they need a rough sketch. Well, the Supreme Court has provided one, idiots. In a case that the office cited themselves called Armstrong, says the government must assemble from its own files documents which might corroborate or refute the defendant's claim. There's no mystery about what the prosecution must do. If it seeks to establish that this case is based on permissible motives, which it clearly is not. So they're like, well, we don't know what to do. How do we show you that we're not corrupt when we're corrupt? See, they're very confused. Well, that means if we show you everything, then you're going to see that we're corrupt. So what do we do? Well, you're going to have to show us. And so they submit this motion. They say in conclusion, for the foregoing reasons, President Trump submits that this indictment should be dismissed on the basis of selective and vindictive prosecution. And in the alternative, the court should hold a hearing to develop the record about the due process violations committed by Jack Smith and his office. Good motion from Todd Blanche and John Lauro. We had a nice reveal there that these prosecutors have been on this case for a long time. And they were actually already essentially prosecuting Trump before the special counsel investigation even started. And they just picked up their files and brought them over. And they already had come to their conclusions. So Jack Smith's investigation was not new and independent and impartial. It was just a carryover of other partisan hack prosecutors who already came to their conclusions in the aftermath of the election before they could have even come to a conclusion in the aftermath of the election. And of course, they are exposing themselves in this prosecution, but Trump is asking for a bunch of stuff. And you can see as part of their discovery in this October 23 letter to the government. This is from Lauro and Singer, Trump's defense. And they say to the government, Dear Mr. Gaston and Mr. Wyndham, we are writing for a bunch of different discovery, and we're going to be asking for a lot of it. But look at this. The rest of this are requests. And I just wanted to share with you what it looks like because there's a lot of it. Please provide all documents and information about, look at this first one. Yes, about informants, cooperators, undercover agents, representatives, anyone acting in a similar capacity at the behest of the DOJ or any law enforcement agency that was taking place within 5 miles of the Capitol on January 6th. That is money in the bank right there. That is what we want to see. Discovery of informants. Now, the judge is going, well, it's not really relevant because they did this in all of the other cases. This was the same thing we saw with the Oath Keepers and the Proud Boys, and they said, no, you don't need all that. So please provide documents about informants, cooperators, representatives who are working at the behest of the DOJ or who are involved in the assistance, planning, encouragement, trespassing at the Capitol on J6. Please identify all consideration or things of value, money given to people protesting, breaching, trespassing the Capitol. Documents about security for the National Guard, law enforcement, anything related to the ellipse. Similarly, how about alternate electors? Things about state legislature involvements in alternate electors. And this list just goes on and on and on. State legislatures, investigations related to fraud. We want to know security risks that came from a cyber attack about SolarWinds, Microsoft, and VMware in 2020. We want to know about Dominion voting systems products, ballot marking devices, precinct optical scanners, and so on. Everything from the Dominion Democracy Voting Suite. We want to know about the Russian advanced persistent threat called attacking the SLTT. Under this, how about the Iranian persistent threat? Allied security groups work. GBI strategies work. Information about Coriolis. Documents provided to Trump. Anything about voting anomalies and irregularities about the 2020 election. Documents about changes to state election statutes, which we covered tons of. Anything about assessing potential voter fraud. And look at the list, my friends, okay? It just keeps going. But communications between NARA and the DOJ responsible for the investigation of election-related crimes. All documents about executive privilege and the Presidential Records Act. U.S. Postal Service. Anything about referrals referenced by Lisa Monaco, Deputy AG to Merrick Garland. All documents from Michael Sherwin on 60 Minutes. All documents sent to this location. Please tell us about the destruction of the January 6 files. Please provide all documents related to communications from Jack Smith's office to the Joe Biden team, and all documents about Mark Milley, all briefings provided to Trump regarding election security issues, and so on. Tell us more about Beth Sanner and Edward. Anything that might reflect the motivation of a witness. Give us Agent Garman's personnel file. Oh my goodness, this is great. Please confirm you've conducted a case file review consistent with the department manual, and please submit all of these on a rolling basis. Let us know if you have any questions about this or you'd like to discuss any of this. Sincerely, your friend, John Lauro. Dang, son! That is what I like to see, okay? That is a juicy, juicy discovery demand. There's a lot in there, right? So you get the picture. Trump's defense is asking for everything, and I hope they get everything. And they should make all of this, as publicly available as they're allowed to, what is inside. And so Trump and his defense blasting and busting the government. Of course, they're all partisan in this case, and sought to prosecute Trump. Now they're getting their wish. Trump is going to be making this argument. Prediction, Judge Chutkan denies it, and then we'll see if he appeals it up to the higher court, and this will be addressed later. And so, my friends, we'll be here continuing to cover this. Thank you for joining us. Thank you for subscribing, and thank you for inviting somebody over to our channel to see what is happening in these cases at the depth that we need to review it at, because the media is just covering this stuff topically. There's a lot more going on. So thanks for inviting him over here. Thanks for checking out robertgovea.com, and we'll look forward to seeing you on the next one.